Okey, hari ini kita buat satu press conference berkenaan dengan banyak isu. Semuanya ada kena-mengena dengan isu pengampunan, the pardon matter. So, saya akan bercakap dalam bahasa Inggeris, one version. Kemungkinan ada paper, kemungkinan kalau dah siap, ya. Kalau tidak, saya akan buat press conference dulu. Then you have any question you ask, and by the time hopefully we get the reference for you to write. Is that alright? Okay. Now, as you know, the process of pardon was initiated by us on the 1st of September 2022, which actually were a few days after the conviction by the federal court, not by the review court, by the substantive federal court. So we quickly put in the pardon papers. Now, September 2022. Then we followed up with two what they call addendums. Addendums are just additional. You can call it volume 2 and volume 3, but they form one group of a single pardon paper. The first addendum was 18 October 2022, and the second addendum was 20th April 2023. Now, why I want to lay this background so that you know some of the ridiculous questions that has come up in the public, even by some purportedly intelligent people have been talking a lot of nonsense. The reason why I raise this is because in all three addendums, our single attack for purposes of getting pardon is because we said Datuk Seri Najib never got a fair trial, especially at the federal court when the request for adjournment by his new counsel of 3 weeks old were not granted, and the federal court proceeded to hear the appeal, although Datuk Isham Tepotik did not make any submission because he could not. He was not prepared. The worst thing happened was they heard the other side, who's got nothing to do with the appeal. They are only responding. So that was a very serious breach of fair trial, which the court in review 4-1 decision that one person, which was Tan Sri Raman Sebli, agreed with us that he should be acquitted purely on the issue of lack of fair trial. Now, you may be wondering, I hope you are a lot more open-minded than the Bar Council, because the Bar Council seems not to understand what is fair trial. Maybe because the President now has never done a criminal trial. You remember there is a case called Lee Kuan Yew. Lee Kuan Yew was a federal court case. And who presided? Richard Malanjum, Hashim Yusuf, and the person who wrote the judgment was Gopal Sriram. Okay? So very familiar figure. In Lee Kuan Yew, he was charged for drug trafficking. The case was overwhelming. Very important for you to bear in mind. Case was so strong. So the High Court judge said, forget about submitting at the end of the prosecution case. I'm calling for the defense because case is overwhelming. Enter the defense and you put your defense. So he was convicted, sentenced to death. Court of Appeal sentenced him to death, confirmed, went to federal court. In the federal court, he complained that his right under Article 5 of the Federal Constitution, namely the right to a fair trial, was breached. All the three judges, written judgment by Gopal Sriram, said, yes, it may be a case so overwhelming against him, but he has got the fundamental right to a fair trial. You just imagine any of your relatives deprived of the right to be heard when your neck is at stake. You're about to be hanged. You were told, we don't have to hear you because the case is overwhelming. Okay? Now, that was as simple as that in Lee Kuan Yew. But in Datuk Seri Najib's case, he never had a chance to be heard in the federal court 100%. Not heard. Because they refused to adjourn. So it was on that basis, the first volume went in to say there is no right to a fair trial. So it is for that reason, Tan Sri Raman Sebeli said there was no right to a fair trial given, and the order was logical, acquitted and discharged. Lee Kuan Yew got acquitted and discharged because the procedure was not followed, fair trial was not followed. So you understand that, eh? Now what is the second volume? You'll be wondering, why second volume? The second volume is about a set of illegality that happened that put my client in a position of not having a fair trial. You remember there was a task force, I think if I'm not mistaken, headed by Datuk J.C. Fong from Sarawak. He had a task force. The idea was to find out whether the appointment of judges were legal or not following the protocol and the law regarding the Judicial Appointment Act. Now, the JAC, Judicial Appointment Committee, recommended, according to the Act, very lawful, recommended for Chief Justice Tan Sri Datuk Seri Azhar Muhammad, a federal court judge. President of Court of Appeal Tan Sri Rohana Yusof, and Datuk Abdul Rahman Sebeli, interestingly, as CJSS. The other fourth category not discussed. Yeah? But what happened? Tun Dr. Mahathir Mohamad, together with his famous AG called Tommy Thomas, decided that they should ignore the JAC and therefore ignore the Act. And what did they do? They did not accept what is bound for them to accept. Instead, they appointed for Chief Justice Richard Malanjum, not even in the category of recommendation. Then they appointed Tan Sri Ahmad Haji Ma'ruf as President of the Court of Appeal, whose name also never appeared. Then you have Tan Sri Zahra Ibrahim. They appointed her as Chief Judge of Malaya, and Datuk David Wong Dakwa as Chief Judge Sabah Sarawak. Now, what happened next is interesting. I want to shock you, because CJM Tan Sri Zahra Ibrahim, within 4 days or 5 days of her appointment, flipped the judges. Sofian, who was already hearing the SRC case, already hearing, remember he gave the gag order for no rhyme or reason, he was taken out, put in civil division, and one civil division judge called Nazlan was put in the criminal division to hear Datuk Seri Najib's case. No rhyme or reason. I have written to her and say why. And she answered me and said, oh no, there's nothing wrong with the judges. It's just a routine transfer. You know it is not a routine transfer. Why routine transfer in the middle of a case? Alright? The rest are history. You know what happened to the SRC case. So this is part of what we say. We don't care what the Nazlan did. He may have done the best of effort. We don't care. But we are asking, in the case of Sufyan, it is a random selection by computer. You put the system in place, the judiciary. So why can't you stick to it? Why do you change the goalposts when it comes to Najib? So my question is, how is Nazlan appointed when he was targeted and appointed without random selection against the judicial punya practice? Okay? Now then we have the second addendum, which was on the 20th of April 23. This is about Justice Nazlan's conflict of interest, one part. You remember the Maybank issue? He was the Consul General. He also advised on SRC and also one MDB, and we say you're in conflict. That's one part. Second part, we put in the two judgments in the review. 4-1, remember? We put the majority judgment, which was hardly anything. I think it's about 11 pages or so. And then we put the very detailed judgment of Justice Rahman Sebli to say, look at the argument, and I don't want to argue, you read it yourself. Basically, we told the Yang di-Pertuan Agong, you read it yourself, see which one you like, which one you prefer. Because quite certainly we are confident, if we read Rahman Sebli's judgment, you'll be persuaded for an acquittal, yeah? Because no right to a fair trial. So you notice these three documents all about, I didn't have a fair trial. I didn't have a fair appeal. Nothing to do with the issue of the normal pardon. Namely, I'm sorry I committed the murder. I'm sorry I stole the money from the bank. I now throw myself at your feet for mercy. Please give me mercy and therefore reduce my sentence. This is not the case. This is the case. I am repeatedly saying I'm not guilty because you didn't try me properly. You didn't behave fair to me. So in the context of that, what is the Bar Council talking about? And this group called G25, I don't know where they come from, G25. G25 say, how can you reduce the, by way of pardon, the sentence? Because he didn't plead guilty and say sorry about what he did. Are you stupid or what? Because the idea of the pardon is about fair trial. It's got nothing to do whether he admitted he's guilty or not. So G25 and the Bar Council completely are ignorant and completely miss the boat. They don't understand the law. All right? But I'm not surprised with the Bar Council not understanding the law because they don't understand their own charter. They have lost all the cases under Legal Profession Act. Now, I want to go next to this. What happened at the pardon? You have been waiting for this. Okay? Now, the pardon started, the actual discussion, detailed discussion on the 8th of December 2023. Very detailed. I think it went on for a couple of hours at least. And they discussed Datuk Seri Najib matter and so on. It was going in a particular direction, which I am not entitled to say. It's not nice, because it is supposed to be a secret thing. Because they were legal, I won't discuss it. But what happened subsequently was, the Yang di-Pertuan Agong said, I will make a decision later, not now. So he adjourned the matter, and that's what happened. You notice that he went on initially to 15th of January, and then further postponed twice, finally to 29th of January, which was recently. Okay. So, what happened on the 29th January? Because 29th January, I mean, you have already discussed 8th of December. 29th January, you're supposed to give just the result. I am told, and I'm confident this happened, otherwise I wouldn't dare tell you this. On the 29th, the Yang di-Pertuan Agong was thinking of a full pardon. Okay? But he wanted to be sure. He passed votes around, 4 empty vote papers. He passed around to the 4 non-permanent members. Put yes or no, full pardon. The result came back. I don't know what is the result. Then he said, never mind, I have decided the alternative. And the alternative is what is, you got the result. But even the result, I'm going to tell you, there's a lot of contradiction, which I will elaborate in a short while. But why I want to mention to you about this voting system is, with the greatest of respect, pardon is the sole prerogative of the Yang di-Pertuan Agong. He can listen, in fact, he should listen to advice, opinion and so on, but he doesn't take vote. He shouldn't. He should decide on his own. He can say, I'm rejecting all advice and opinion, but this is my decision. And there's nothing you can do about it. You cannot challenge in court because that's the royal prerogative. This is an established law, at least 8 cases in this country that I've decided that you cannot challenge, and that discretion is absolute. They are not bound by any advice. But Karen Chia, the chairman or the president of the bar, seems to think otherwise, in spite of 8 cases looking at her face, that you cannot challenge. It is a discretion, complete discretion of the Yang di-Pertuan Agong. She said, no, you ought to listen to the 4 or 5 other members of the board. Yeah, I think she should go back to law school. She doesn't understand the law or the constitution. Now, the next I want to mention to you is this. You must have seen the official media release from the Prime Minister's office. But this Prime Minister's office is a department. Yeah? I must be very clear. It is not necessarily from the Prime Minister's own office. Now, the media release is this. I'll take one by one and show it to you. I think you have seen this. All right? You have seen this. Now, if you see this, you will realize this is dated 2nd February 2024, Friday, Jumaat. You notice the dates and everything is all typed. In one go, in one fashion, it is typed. All right? But what is wrong with this document? This document say, diberikan pengurangan 50% bagi hukuman dan denda yang perlu dibayar, which is a very clumsy sentence. Not by the Yang di-Pertuan Agong, but by this department, whoever it is who drafted it, because somebody didn't do the arithmetic. 210 million, 50% is what? It's not 50 million. So the Yang di-Pertuan Agong must have said 50% discount of imprisonment and 50 million fine, not 50% discount on both. Okay, so this is very clumsy. But the worst thing is this, that this document seems to suggest that it was the board, the pardons board, that decided the pardon, not the Yang di-Pertuan Agong. It was the pardon board. It says, setelah menimbangkan pendapat dan nasihat, mesyuarat Lembaga Pengampunan Wilayah-Wilayah Persekutuan Kuala Lumpur, Labuan dan Putrajaya kali ke-61 telah memutuskan hukuman ke atas yang berbahagia Datuk Seri Najib bin Tun Haji Abdullah Razak diberikan pengurungan 50% bagi hukuman dan denda yang perlu dibayar. So clear kan? After listening to their own advice, the board decided, not the Yang di-Pertuan Agong. Of course, the board includes the Yang di-Pertuan Agong, but it should be just the Yang di-Pertuan Agong. Now, whether the correct thing happened or not, we do not know. But we go by documents. This document is dated 2nd February. I suspect this document came out first. Okay? First, earlier than any other document pertaining to pardon. Interestingly, I don't think you have seen this because my client received this because she is a person affected. Have you seen this document? No. Okay. This is a document that is signed by the Yang di-Pertuan Agong. Dulu Yang Maha Mulia, Yang di-Pertuan Agong, sign it, first page. But as usual, the royalty, especially the top royalty, will sign at the top. They never sign at the bottom. And there is a seal. Now, the announcement is made by somebody called Yang Berhormat Dr. Zaliha Mustafa, who is the Menteri dalam Jabatan Perdana Menteri Wilayah Persekutuan. So he was the Menteri of Wilayah. Now, they must have realized this is wrong. Okay, this announcement was wrong. So they corrected it. They now say, after all the preamble, they now say that bahawasanya, I won't read all. Lembaga Pengampunan bagi wilayah-wilayah Persekutuan Kuala Lumpur, Labuan dan Putrajaya kali ke-61 melalui perkara 42 di bawah Perlembagaan Persekutuan pada 29 Januari 2024 menimbang hukuman banduan dan menasihatkan Seri Paduka Baginda. Now they talk about advisory. Yang di-Pertuan Agong supaya banduan Datuk Seri Muhammad Najib bin Tun Haji Abdullah Razak meneruskan baki hukuman. Okay? Then they say this. It's very odd. One is a third party kind of talk, and now the Yang di-Pertuan Agong talk in the same document. It says, dan bahawasanya adalah munasabah pada hemat beta. Belas kasihan patut diberi kepada Datuk Seri Muhammad Najib bin Tun Haji Abdullah Razak. Maka oleh yang demikian, beta Al-Sultan Abdullah Riyatuddin Al-Mustafa Billah Shah Ibni Almarhum Sultan Haji Ahmad Shah Al-Musta'in Billah ke bawah Duli Yang Maha Mulia Seri Paduka Baginda Yang di-Pertuan Agong ke-16 pada menjalankan kuasa yang terletak pada beta oleh perkara 42 Perlembagaan Persekutuan dan semua kuasa lain yang membolehkan bagi maksud itu adalah dengan ini memerintahkan bahawa Datuk Seri Najib dibebaskan pada tarikh pembebasan awal iaitu 23 Ogos 2028 dan denda dikurangkan kepada 50,000. There is no 50% lagi dah. All these are corrected. Sekiranya denda tidak dibayar, tempoh penjara bagi Datuk Seri Najib ditambah selama setahun. That means 23 Ogos 2029. Pada menyaksikan yang tersebut di atas, beta telah menurunkan tanda tangan dan cok mohor beta pada 29 Januari 2024 but signed by Dr. Zaliha. But interestingly, I'm sure the Agong did the right thing because he has to make a decision. Those people who prepares the paperwork are the one who blunders. Look at the date, it's chopped. Why is it not typed in one go? Because this is on the 29th, the date of the decision. Nampak tak? It's chopped at the bottom. Okay? Now I ask you a very simple, logical question. If this existed on the 29th January, if this existed, I'm thinking it did not. Okay? How could a blunder be made on the 2nd of February? If you have this, how did you blunder this? This is what date? 2nd, which is a few days later. But you have the benefit of this. And there is a chop, which is very suspicious. So when was this made? And when was this made? Okay? So it's a very interesting question of law. At this point, I'm going to tell you, we are seriously thinking about another petition of pardon. A full pardon, they call it a free pardon, which we have asked before. We want to reiterate that. We're waiting for the right timing. We will do it. Okay? Now, I next go to another issue. But I conclude by saying on that part, whether the Pardons Board decision or the Yang di-Pertuan Agong decision was regularly made or not, it's not for us to discuss because it is unchallengeable. But I want to show the troubling spots that are there, and I keep on wondering, why is my client bullied In the court, he never received fair trial. In the pardon also, he's not getting a fair cut of the procedure. Everything seems to be a blunder. So why is it on Datuk Seri Najib? You know, it didn't sound right. The public like you, who represent the majority of the public, they would want to know what actually happened. All right, now I want to comment. There are various members of the public, as I've said, who has made comments that are untoward, they are quite ignorant, and so on. They have asked questions like, should he get a pardon at all? Should he even get a reduction? So a lot of maki, chachi and all that, again, Datuk Seri Najib. Failing to recognize the concept that our request for pardon is anchored on lack of fair trial. Nothing to do with I'm sorry, tolong, you know, nothing to do with that. All right? Now, second, there was also, as we said, there was a total deprivation of fair trial. We got one recognition by Rahman Sabli. And we said, look, read it. This is a man of immense knowledge, very senior. He's now Chief Judge of Sabah Sarawak. Don't ignore, look at it, what he said. Then there is the Bar Council rhetoric through Karen Chia. They say, you cannot believe this. Karen Chia said, there is due process. Why can't you obey due process? You know, the point I'm asking is, this particular Karen Chia, that's precisely it. We are saying, why don't you obey due process? They are asking us, they're telling us, why don't you obey due process? We're saying, yes, please obey due process. Give us the right to be heard, which you did not. And because you failed, you should acquit him. Datuk Seri Najib should not be in the prison, not even for a day, because his constitutional right has been taken away. Now, if that happens to any one of you, your relative, anak, cucu, and so on, you want to be reminded that you have a robust system. It doesn't matter whether you're guilty or not. And I'm not saying Datuk Seri Najib is guilty, because I'm confident we could have won in the federal court. If there was a set of judges that were fair, we would have won if they had given us the right to be heard. We're saying, if you had made a mistake against any one of us, any one of you, if the court made a mistake, that mistake must favor you. You ought to be released, because the system is the whole government, the whole agency of the state, pinned against one individual. You are the only individual focused by the system so that you'll be punished. So anything wrong committed by the system, you should get the benefit. And that should be our system. And then when we go back to bed, sleep at night, we will be, you know, in a peaceful sleep. And when we die, we know our children and our grandchildren are protected by a very robust system. This is a system that you cannot trust, because it depends who you are. All right? Now, and I'm saying this in the light of the recent few people that were charged, including Tun Daim, and I'm sure there'll be a lot more being charged. I'm saying, please give them the same right of a fair trial. Then you will know that when they are convicted or acquitted, you know that they've got their fair share of the judicial system. Okay? Now, then there are people who says that there is an academic opinion. Professor Shad Faruqi said, of course, he is an honest man, quite decent, but I think he's wrong. What he said is, because there is a date given to Datuk Seri Najib punya pengampunan. Remember I read to you 2029? Yeah, there's a date. Dia kata, because the date is given, you cannot get remission. Remember the 2/3 remission? You get 1/3 automatically off. You serve only 2/3, and then minus holidays here and there, then you'll get further discount. They kata because there is a date there, you cannot get the remission. I say no, it's wrong, because you know, you have been in court. Sometimes judges say, all right, I sentence you to 5 years imprisonment from the date of arrest. So basically, you're going to serve, and the judge sometimes calculate until 20-something and whatnot. Now, are you saying, therefore, those people do not get remission? Of course they get remission. Just because a date is given doesn't mean that remission is removed. Yeah? That date is just given as a date that is calculable for you to know how long am I going to stay, and then the additional one if you don't pay the 50 million. Okay? So these are my observations. I don't want to say too much, but I think I've taken quite some time. So I want to leave it to a more interesting dynamics of question time. Yes.
When will you apply for a new pardon?
I'm waiting for... No deadline. Those who say, you know, there's a lot of people who are lawyer buruk, who keep on saying, you must serve 3 years, then only you can apply. They have forgotten there are exceptions. I've just given you how many exceptions of what went wrong in the first pardon. Yeah? I must reiterate, my client is not totally happy about the fact that he didn't get a free pardon because of what he has been denied of. But to answer your question squarely, we are waiting for the right cue from my client when to put in the next paper.
Full pardon, right? Seeking full pardon.
Yeah, it's either a full pardon, you can call it full pardon, or free pardon. All right? You understand that the concept of pardon, especially a free pardon, that means you are pardoned of guilt and the sentence. That means you are as though never guilty at all. Like Datuk Sri Anwar, like, if I'm not mistaken, Datuk Harun Idris, and the likes. Okay?
Tan Sri, you mentioned in so many words, would you be able to tell us in brief why you're submitting another request for pardon? Okay.
The reason why we wanted to make another request is because we don't think the Pardons Board, without denoting any blame to any particular person or persons, I don't think the Pardons Board operated the way the Constitution expects them to operate. The Yang di-Pertuan Agong merely hears opinion and advice, which he must. He must hear the advice and opinion, but he decides on his own. Because, I mean, he's not the king for nothing. Here, he is truly the king. Yeah, he's a prerogative of mercy. He decides himself.
Tan Sri, what about parole?
Okay, parole is operative only under the current condition where there is, what they call it, term of imprisonment. If this term of imprisonment stays without being revised, or a new pardon matter has taken place, parole is the job of the prison. So they will consider whether you can be on parole. They can even make several recommendations.
Do you need to apply for that? Or?
Actually, it is automatic by the prison because they review it every, what they call it, standard period. They review every prisoner's situation, whether this prisoner ought to be given a parole or not.
So based on current situations, do you think that Najib can be out maybe next year or earlier than 2026?
It is possible. It is possible. But as you know, my mind has not been directing towards that. Yeah? But the answer is yes. It is possible. That's why I said what the academic opinion about not getting the remission is wrong. Because parole involves remission.
When is it?
We don't know. We don't know because I think the prison authorities have never seen document like this, especially rather checkered. So they will have to make some sense out of it.
Just want to ask you this question. You said you're waiting on word or instruction from your client in regards to submitting a new request for pardon.
Yes.
What is your criteria or date in which you would pick to send this request for pardon? Is there a specific date? What kind of time frame What kind of stars have to align in order for that to happen?
I don't wait for any stars. Although to the Chinese they'll be quite happy. Although I'm born in the year of the dragon, we don't work on the stars or the year. But certainly I don't want to push it too fast, because the young di-Pertuan Agong has not warmed up his seat yet. So that's one criteria, for sure. Yeah? And the other criteria is I want to wait for my client instruction as to consideration of other factors.
Tan Sri,
Yes.
talk about pardon and then the constitution. So it's hak mutlak YDPA.
Yes.
Right. So why the discrepancy when it comes to the previous YDPA? I mean, he has a hak mutlak. Why is he
I think
not following that?
it's like this. There may be a lot of sultans of various states who may have a lot of experience. One thing I can tell you, the Sultan of Johor, who is now the young di-Pertuan Agong, he had plenty of experience, because he's famous for calling up prisoners who have been in the prison for 38 years. Can you imagine? Prisoners were supposed to be just 20 years, but happened to be there for 38 years and were literally about to die. So he has exercised mercy. He has pardoned so many of them. And I know Perak has done the same. I know Selangor is regularly doing the same. Maybe because these states have got a lot of crime, because they are by the nature of the states, kan? Johor.
Population.
Yeah. So population, maybe it is a question of how used are you to the issue of pardon. But somebody should have advised that this is hak mutlak. Hak mutlak, unchallengeable. You can't challenge it in court. The other matter is, many people say, why don't you give reason? Okay, the answer in law is, he doesn't have to give reasons, but I will be the first to tell, as an advice, that if it involves people like Datuk Sri Najib, involve people like Datuk Sri Anwar Ibrahim when he was pardoned, or Mokhtar Hashim, these are characters that are important. Maybe giving a reason goes a long way towards a good public administration. I would encourage them. But the answer is, there is no requirement.
Tan Sri, any word from the United Nations group?
Good question. We know now the file has moved, and they take quite some time, because they got plenty. And there are only about 11 of them. And they sit in a batch of 7 to 11. So our turn has just come in, and they are already studying. So I'm hoping that will be an additional factor towards the bid for pardon.
Tan Sri,
Oh yes,
as Datuk Sri Najib maintains his innocence from the very beginning,
yes.
can we take it that he has not paid any part of the fine?
No, he has not. Because, as you know, where did the money go? Money went to all the welfare and to all political works. There's no money that went into his pocket. You see, a lot of people have forgotten about this. Let's punish him because he has taken the money. The question is, did he take the money? And that is consistent with what he said. I thought this money came from the Saudi Arabia king, because in the presence of 3 other ministers, there was a promise of a financial help to bring about the Malaysian government into a moderate government, which he led. So because of that, when the money came in exactly as promised, he spent it on political matters, welfare, and he has helped a lot of poor people throughout the country. But nothing he kept. And to put a cream on the, or rather icing on the cake, 620 million US. You see, he received 689 million US. You convert that, it becomes 2.6 billion ringgit. 689, okay? He used a portion of it for the election, welfare and so on. he returned 620 million US, which is about what, 75% of what he received, back to the account that he thought donated it to him. So, can you actually say, as what Dr. Mahathir is saying, this is the work of a penyangga? This must be a real gentleman penyangga. You know, who took money and returned it. Return the money that is not used.
That's right.
Yes.
As for the first royal parliament application, since I think Dr. Sri asked for a full parliament, but in the end only got nomination. So did he tell you what he felt besides or disappointed?
He's disappointed. He's very disappointed because he has always argued, consonant with what the minority decision in the federal court, that he should not spend a day in the prison.
There was interference in the decision making at the pardon's court?
A lot of people say that, but I cannot say it because, you know, I act on evidence. I don't have evidence. But everybody is free to sort of, you know, think about it. Yeah?
Terima kasih. Jadi tersebut kali pertama penggunaan kali pertama tu disebabkan Dr. Sri Najib tak dapat pertukaran yang adil.
Yes.
So adakah yang kali kedua ni disebabkan oleh proses pengampunan yang tidak adil? Berlaku kepincangan dalam proses itu.
Very good question. See, for those who did not hear, this is also in Malay. Let me translate. Yeah. His question is this: my first pardon paper was on lack of fair trial, and then he picked up from what I said. There is also a lack of a fair assessment in the pardon. Am I going to incorporate lack of assessment of the pardon as something unfair in the process as the basis of my second pardon request? The answer is yes, for sure, among others. Yeah?
Okay.
All right?
Thank you.
Thank you very much. Thank you. Thank you. Thank you. Ah, tangkap kau. I don't know whether I can give you. You know why? It's personal to holder, and I think there is confidentiality between them.
Or at least can you show it up for all the cameras?
Okay, what I can do is show you the first page.
At least go on.
Boleh? Yeah.
Signature lah.
Yeah. The front page, and I know fully conscious that you're going to take a picture and close up.
Bawa sikit,